listening to a little bit about what I've been doing for the last 23 years. Put together what I call a low-tech presentation. I like low-tech because I'm not here to dazzle or confuse. My goal is to take somewhat complicated concepts and ideas and make it simple so that everybody understands. In here you'll see a packet. In the packet there's a little cover sheet. Cover sheet just says this is my firm. Got a 2-page table of contents. That's the second piece. I was criticized by my associate that spent a long time putting together an outline for me to present, only for me never to look at it once, so I'm trying to do a little better this time. So in this presentation there's 9 bullet points, last one being questions. My goal is to kind of go through this fairly quickly and try to give you guys what I would call the background or the ground rules about estate planning. What is estate planning? Why is it important? How does it all work? That's what I'd like to do. So I just threw my bio. I've been doing this for 23 years after law school in '95 from Chicago, Kent. Much to my grandma's chagrin, I said I've got one more year. That's in Georgetown. So I got a master's in tax from Georgetown. After that, I came back, worked at a smaller firm called Fagel & Haber for a couple of years. Went to a large firm that no longer exists or was merged to somebody else called Gardner, Carton & Douglas. And then at a firm out in the suburbs, I had a crossroad where I had to decide quality of life and value of being a dad and a parent and a husband versus just grinding away at the big firms downtown. I opted for the family and the family values, so I couldn't figure out a way to balance what I was doing. So made a decision. I live in Lake Bluff, so it just became untenable. So joined Kovach, Schifrin & Nesbitt, was there for 10 years. Didn't have the support to support and serve people the way I wanted to from Kovach, Schifrin & Nesbitt. So opened up my own firm. It'll be our 5th anniversary in January. My first piece in the outline is top 10 reasons why to have an estate plan. It's just a simple little bullet point. It's like, well, I've got an estate plan, or I did one. I'm just going to quickly rattle through to get to the meat of the presentation. But estate plan, you want to name the executor or the fiduciary, the person in charge to have to collect the assets, pay the bills, and ultimately distribute it in accordance with the documents. In Illinois, the system is such, if you don't have a will, you can't waive a surety bond. So if you have probate, and I'll perhaps get back to that a little bit, but you'd have to pay a surety bond. That's basically a bond. If I passed away and my wife was the presumptive personal rep under the state law, she would have to post a bond that she wasn't going to steal the money that was going to her and the kids. Not exactly the way we'd want to spend our money. We'd prefer to give it to our family. Again, we can have independent administration if we have probate. Probate is not evil incarnate. It's a nuisance. It's a proceedings through the court system that we would prefer to avoid. How do we avoid probate? Step 1, you create a trust, a revocable living trust. Step 2, you coordinate your assets with the trust. In Illinois, you avoid having to go in the courts and the court system. Every state is different. The way the laws work as it relates to property laws, the same would include for marriage or divorce, is all state law specific. So how states determine how property shifts from one person to the next is state specific. In Illinois, if you have a revocable living trust and you fund it, then you can avoid having to go to the court systems. When I started, I believe the small estate exception was 10 or 20,000. It's now 100,000. So if somebody passes away, they can avoid it with a small estate affidavit, assuming all debts and liabilities were satisfied. Again, important about estate planning is you can decide where your assets go. If you do not do an estate planning documents, a will and a trust, then what happens is the state assumes what you want. Real interesting, when you think about property, I explain it this way to folks. I say there's 4 different kinds of property that one can have. One can have property that they own in their own name. One can have property jointly. For instance, I own something jointly with my wife, Corleen. If I pass away, it becomes hers. That's joint tenants with right of survivorship. In Illinois, if it's your principal residence and you're married, you can own your home as tenants by the entirety. That's a joint ownership that connotes with it the right for it to pass to the other person. The other type of assets is what I would call beneficiary designation assets. We're familiar with that with our qualified plans, our retirement accounts. I'm not talking about annuity type plans that is here for me and my wife and then there's nothing left. Talking about the defined contribution plans, the IRAs, the 401ks, where there's a contribution amount. That amount's for me. When I pass away, it goes to the named beneficiary. Or life insurance goes to the named beneficiary. So joint property, property I own alone, property that has a beneficiary designation, that can include, and as estate planners we refer to it as the poor man's will. I own something and I leave it as a payable on death or transfer on death to my daughter, knowing she'll share it with my son, I hope. That can get complicated. So that is a different way. The fourth way, and the preferred way for most of my clients, is to have a will, just in case you miss something, and then you have a trust. The trust is its own legal entity. It's as if it was you. I call it just a trust. It's a revocable living trust that bears your social security number. So that means it's taxable as if it was mine, but I can retitle or coordinate the assets through that trust. I refer to that as a funnel. So you funnel the assets through the trust. Somebody else is in charge if I'm no longer able, and upon my passing, after just debts and expenses, it goes where I direct. So those are the 4 different ways we can own property. So item 5 in the why should we have an estate plan. Again, Illinois law says, and I've been in court before, where a financial institution is in charge of money that was perhaps wrongful death money or something where somebody passed away. The child turns 18, here's your money, $300,000, $500,000, $2 million, doesn't matter. You're over 18, it immediately vests to you, and the judge will say, bank, why have you not given this money to this adult? 100% all money to a child at age 18. Again, legal adult, but perhaps not as financially mature as we might like. So a part of estate planning is control and preservation. So item 6, creating trust so that we can control when it comes out, how it comes out, to whom it goes. Another concept is, and we'll get to it a little more, is number 7, which is be thoughtful about taxes to minimize taxes. 8, to avoid unintended gifts. 9, 10, to designate who's going to be in charge if I'm alive but disabled. Who's making financial choices for me, or who's talking to the doctors for me if I'm disabled. There's your top 10 reasons why it's important. The next is a super simple checklist. When we sit down and do an estate plan, these are the documents from my perspective that you want to have. You want a will, you want a trust. We typically assign our personal property to a trust. We do powers of attorney for property, health care, and a living will. As a matter of course, I draft a document called Sworn Estate Planning Intent. That is when I'm working for a husband and wife, and I say it doesn't matter whether it's in your trust or your spouse's trust. I work for both of you. I represent both of you. And funding these trusts is not intending to change marital rights vis-a-vis each other. You say, well, geez, we've been married 30 years. I couldn't imagine. I had a 92-year-old client divorce last year. Don't know why, but it is what it is. So now I've got the next part of the packet. The next part of the packet is an important part to understand, whether it's an issue for you or not, specific on your assets and such. But if you look at the bottom of this, I started back in '95 think my chart starts in 97. So if you're doing planning for your parents, you're like, yeah, the federal exemption is 600,000. Correct, in 95 or 97. Spoiler is go to the bottom. The federal exemption amount per person. So as a couple, that's times 2. I rounded to 11.2. It's technically 11,180,000.